Halito, and welcome to Native Chalk Talk, a podcast by natives for all. Here we're keeping our Native ancestors' stories and history alive, while also sharing with you our Native culture, traditions, and more. I'm Rachel Youngman, a Choctaw originally from Anadarko, Oklahoma. I hope you'll enjoy this journey with me as we learn from our Native American guests. And I hope you'll do me a favor. Feel free to like and share these episodes. I so appreciate it. Yakuki.
Part of why I love to study meteorites so much is because they are these gifts from our Creator. Creator has put into each rock a story, just waiting for us to uncover them.
See and share our stories at togetherwe'remore.com.
You're listening to part 3 of this series.
In your and John M. Robinson's review called Hosanna Tabor, Religious Freedom and the Constitutional Structure of the Supreme Court case Hosanna Tabor Evangelical Lutheran Church and School versus Equal Employment Opportunity Commission, you talk about the Native American Church and peyote. Would you share more about Hosanna Tabor and how Native American Church and peyote were applied to the case?
Yeah, this is some pretty complicated stuff, so feel free to just
Go for it.
tell me to shut up. But so this I mentioned a couple minutes ago this case called Employment Division versus Smith, which Congress has reacted to it. In some ways, it's been rejected by Congress, but it's still the law so far as the Supreme Court is concerned. One of the teachings of that case, the Smith case, is that if the government has a general law in place, they can apply that law to you even if you have religious objections to it. So you're not entitled to violate the law even if your religion tells you to do it. That's basically the Smith teaching. Hosanna Tabor was a really interesting case because it involved a school that had fired a teacher, and the teacher had sued the school for violating discrimination law. And this touches on some of the most ancient religious freedom debates of all time. Like, does the government get to decide who's going to be the bishop? Does the government get to pick its clergy? This goes, all the way back to Jesus. Give to Caesar what is Caesar's, and to God what is God's.
Right.
So what the question in the Hosanna Tabor case was, well, if Smith says that you don't get an exemption from a general law, then I guess this school doesn't get an exemption from the anti-discrimination law either, because, if Walmart can't fire the teacher, why should this Lutheran school get to fire the teacher?
Yeah.
And the Supreme Court, and what my co-author, John Robinson, and I thought was a correct case, and it was 9-0, by the way. It's always fun when the Supreme Court's 9-0.
Oh, wow.
This wasn't a liberal, Democrat, Republican, conservative, none of that stuff. All the justices agreed that part of religious freedom is the freedom of religious institutions to choose their teachers, their leaders, their liturgy, their practices, and so on. And a way in which this connects to some of the issues you and I are talking about with respect to Native American religious practices is Hosanna Tabor was a great example, I think. I'm biased, I wrote this, but it was a great example of the court appreciating the more communitarian dimension of religious freedom. The court said it's important for religious institutions to be able to pick their teachers. If you can't pick your teachers, you can't pass on the faith to the next generation. And this was something you and I were talking about before, whether it was that Yoder case about the Amish, or whether it's Native Americans needing to be able to connect their children, again, to place, to land, to community, to tradition. So there's kind of these might seem like very different matters, a Lutheran school and, Native American religious practices, but I think the through line
I get it.
is this communitarian dimension.
So peyote is obviously utilized for religious purposes, but it's also considered a cultural practice. So again, layperson here, is it somewhat doubly protected then?
So the short answer, which is not perfect, I'm going to say no. Because generally speaking, religious practices get special protection that sort of, put in quotes, merely cultural practices do not. Now, the reason why I said this isn't a perfect answer is that there are laws that specify um, the cultural significance and protect cultural practices, even apart from religion. And some of these have to do with Native American questions. You know, um, archaeological sites, for example. Even if they're not religious, they might well be protected, right?
Yeah.
But this is an important point: is that in the American legal tradition, religious practices have been singled out as particularly important. Um, and that's true of Native American religious practices as well. Um, we sometimes we protect sort of culturally embedded practices, even if they're not connected to religion. But
Hmm.
but constitutionally, that's not really true. Constitutionally, in our system, religion is special. In some other countries around the world, they don't do that. They just kind of collapse it all into culture.
Yeah.
Generally speaking, we don't do that.
Okay. Interesting. Well, let's change direction for a moment and discuss Native American burial grounds. What legal protections exist to safeguard these sacred sites and their, religious significance?
Yeah. So there's again a couple layers to this, right? At one level, the act that you mentioned really early in the show um, uh, provides it singles out and provides heightened concern for burial sites, right?
Hmm.
Recognizing that these are important. Um, but in addition to that, you've got some of these federal laws we were talking about, like the Religious Freedom Restoration Act, a lot of religious claimants have used to protect cemeteries and so on, and the
Hmm.
Religious Land Use Act, which again could be used for those purposes. And then the layer even above that would be the First Amendment to the Constitution, which protects the free exercise of religion. So I think there is a sensitivity to the sacrality of burial sites, not only for Native
Right.
Americans but for people generally, really. Um, and I think that when you're talking about these land use decisions that governments often make, again, they haven't been perfect by any stretch. I do think there's been um, greater attention paid to protecting burial sites than there has been maybe to some other uh,
I
religious
agree.
claims.
Yeah, and with NAGPRA now, obviously the remains of humans are also protected as well.
There are regulations in place in most places in America that even if you're talking about private property,
Okay.
but let's say you've got you live in a subdivision in Granger, Indiana, near me, and they discover on your land um, a burial site that the Miami or the Potawatomi Indians is. I mean, there's going to be regulations of what you can even do with your private property.
Right.
We're talking about that. With
True.
respect to government property, um, the protections are going to be, I think, heightened even more because you're not having to bump up against private land interests. Yeah.
Right. Okay, that makes sense. Well, I'd like to highlight the scenario of Oak Flat. According to an article from the newsroom of the University of St. Thomas titled Religious Liberty Legal Clinic Asks Supreme Court to Protect Native Land from October 29th, 2024 by Carrie Hilger. Oak Flat is part of the Tonto National Forest in southeast Arizona. It has been used by the Apache and other tribes for centuries for worship, prayer, and religious ceremonies. The government has protected the land for decades. However, in 2014, Congress approved the transfer of Oak Flat to Resolution Copper. The company says it plans to build a mine that is nearly 2 miles wide and 1,100 feet deep, essentially destroying the area. So you were a law scholar for the Religious Liberty Clinic's brief. And so, what does that terminology mean about your involvement in this effort?
Yeah, so I mean, it's important to disclose that the Notre Dame Law School's Religious Liberty Clinic. Um, we participated in the case as what's called a friend of the court.
Okay.
So we weren't the lawyers for the organization called Apache Stronghold, which was trying to resist this transfer to the mining company, but we tried to help them. We filed legal briefs in the courts,
Fantastic.
both courts of appeals and the Supreme Court. Um, the precise legal issue is one that you and I were talking about a little earlier. It's um, you know, if the government makes a decision about what it wants to do with its own land, does it have to take account of the fact that that land has religious significance for people? In particular, does it have to take account of the fact that that land might have religious significance for Native American peoples?
Hmm.
Um, I mentioned, early in our conversation, this case called Ling, where the Supreme Court had, again, I'm simplifying, but it said that doesn't count. It doesn't count as the burden on religion. It's our land. We get to use it the way we want. If we
Right.
want if we want to accommodate Native American sensitivities or beliefs or practices, we can, but we don't have to. And that's kind
Right.
of been the law for a while. The question now is, well, does that same standard apply when we're talking some of these new statutes like the Religious Freedom Restoration Act or the RLUIPA? Um, the position that Notre Dame's clinic took was that these lower courts had gotten it wrong, and that it should be it should count if the federal government is going to use its land in a way that's going to completely destroy the ability of this tribe to practice an aspect of their religion. Um,
Right.
now, it's worth emphasizing that even if you say it counts, which is our position, this should count. That doesn't necessarily mean that the government loses. It just means the government has to justify what it's doing. Like the way religious freedom law works is like it's almost never the case that religious believers have an absolute right to win. Sometimes
Right.
religious believers lose because sometimes the government's got to do what it's got to do. This can sometimes come up in very painful cases having to do with things like vaccinations or other conflicts. The people, the religious believers sometimes lose these cases, even though the government says, "We get it. This burdens your religion. We're going to vaccinate you anyway." And I
Right.
realize it's a controversial question. Um, the thing about the Oak Flat case is the Apache stronghold wasn't even allowed to that step two of like basically saying, look, you're going to burden our religion. Tell us why you have to do it. Is there some other way? Can you accommodate us? Is there some other compromise? They just said
Right.
it doesn't count. Now, where that case is right now is the Supreme Court decided not to take it. So that doesn't mean the Supreme Court agreed with what the lower court did. It just means they decided not to take it. And sometimes courts decide not to take cases, and they don't have to tell us why they
Huh.
don't take cases. Um,
Right.
so this issue is going to keep on percolating. But just for your listeners, and I know we've talked about this earlier in our conversation, but um, it's a fascinating, difficult question. Um, what limits are there on the government's ability to use its own land in ways that it wants to, when those uses will conflict with the religious freedom interests of citizens, including Native American practitioners of traditional religion?
Right. Well, I can see where there is so much controversy around that. First off, there's the religious protection, and then there's the government who's going to do what they want to do in many cases. And so I guess the best folks can do is take it to court, try to fight it, try to take it to the Supreme Court. But again, if it gets rejected from that point, it's a losing battle, correct? Sad as that is to say.
So, not necessarily, right? If one loses in the courts, one can still try to convince administrative agencies and Congress and federal governments and the federal government rather, to change their policy. Just because the court doesn't tell them to do it doesn't mean it's a
Okay.
loss. Yeah,
Okay.
you can fight another day.
Right. We live to fight another day.
Yeah.
Well, this brings me to a topic that I've always wondered about. First off, is it proper to say tribes are sovereign nations within a sovereign nation? Because I've thought about it that way, but I don't know if that's the proper nomenclature.
It is. There's some footnotes you'd want to add. Sometimes the courts have used the term uh, uh, domestic dependent sovereign. So it's not Native American. recognized tribal governments are sovereigns, but they're not completely sovereign. But they do have governmental relations with federal government, the national government, and with the state governments. Um, kind of if you want to think of like the two bedrock features of American public law dealing with the tribes is that um, it's the federal government that deals with tribal governments. It's not the states. So that's the relationship.
Okay.
And tribes are governments, and they are, at least to an extent, sovereigns. Like, so, people are citizens. I think at one point when you and I were emailing, we talked about dual citizenship, and I think that is
Hmm.
appropriate. Native Americans are citizens of the United States, but
Right.
enrolled tribal members, at least of federally recognized tribes, are also citizens of those tribes. What that means can be complicated when you're talking about land use, or, you know, I don't think like a Native American tribe probably wouldn't be allowed to. The federal government probably wouldn't let them like set up a nuclear arsenal or something like that.
Right.
um, and
Yeah.
that you can't really have your own foreign policy, that kind of stuff. Um,
Mhm.
but it is meaningful to say that the tribal governments are sovereigns, and that sovereignty has implications for what state governments can do.
Yeah. And if you are there any other scenarios where, like, most countries that have been invaded and they've been taken over, there usually isn't that dual scenario where it's like, yeah, we've conquered this land and these people, but we're still going to let you have some freedoms and have your own sovereignty within this larger sovereign nation. Can you think of any other country that's like that today?
Well, it is unusual. I mean, I think there's something like it in some of the sort of post-colonial African nations, something like it
Okay.
in Canada and Australia. But as we discussed earlier, if you think about all of the migrations and invasions that have happened for all of human history, um, people, when Genghis Khan kind of rolls over all these countries, he's not worried about making treaties with people, right?
No.
Um, the When the United States expands and invades, um, it it makes a choice early on to deal with the tribes as kind of the kinds of entities that you can make treaties with. Now, you might say they kind of imposed that on them, like they said, we're going to treat you as if you're sort of European kingdoms or whatever. Um,
Right.
but um, again, we're a relatively new country, and that certainly hadn't been done in the past. Again, when the well, I'll get my history wrong, but my sense is that all these Europeans were like running over each other all the time for centuries, and
Right.
nobody bothered to
Yeah.
worry about treaties very much. So our situation is unusual. I don't think it's unique, but it's new-ish.
Yeah. Yeah. When you put in perspective of the country not even being that old, and then on top of it, things were changing over time. This happened at a time when there was a different train of thought when it came to conquering lands.
What we think of as like the nation state, you know,
Yeah.
it didn't really exist until about 500 years ago. Any historians who are listening will probably quibble with me, but that's a generalization.
Yeah.
So if you think about, one group of people conquering another in the year like 800, they weren't worried about treaties and domestic dependent sovereigns and so on. It was just, this is the warlord who's in charge now, you know. Uh,
Yeah.
but Canada is probably the best analog, I think, to what
True.
because they have a national government, they have provincial governments, and they have indigenous groupings of people that they use different terminology than we use, but that
Yeah.
they have tried to preserve some kind of domestic dependent sovereignty, like we have.
True. That is probably the only one I can think of too. If there are any listeners out there that have any other thoughts, let us know. So it can be challenging to keep these two worlds from colliding, these two sovereign nations. So, what are your thoughts on how they can coexist?
Well, so we're getting a little bit away from all those fascinating stuff. The- Um, I like to think I'm kind of an expert when it comes to law and religion. When it comes to these bigger questions, I've got some views and I know some stuff, but I don't want to pretend to be an expert. So you
No
should
worries.
take this for what it's worth. Um, I think that in the modern world, it should be easier to accept the idea of multiple communities, multiple sovereignties, multiple loyalties. I think that technological advances, the digital revolution, all these kinds of things should make it more possible to have kind of multi-layered governance systems and pluralistic governance systems. Think about the EU as just one
Yeah.
example. That really wouldn't have been possible for a while. Arguably, it's more possible now. Um, so I mean, I don't think we're ever going to see, although it's what was Yogi Berra said, it's hard to make predictions, especially about the future. But I don't think we'd ever get to a situation where like um, the United States of America sort of declared we're no longer a thing.
Yeah.
We're going back to the nations that existed before we got here. That's not going to happen. Um,
No.
but I do think that it strikes me that it's reasonable to think of, and we could get creative about this, new corporate structures and so on, but it's reasonable to think of um, more pluralism and in a way more robust kind of tribal agency and sovereignty and
Yeah.
independence and autonomy in a lot of areas. Not in all areas, just like, you know, when our country started, the states had all kinds of authority to run stuff that now the national government runs. You know,
True.
a big one we had a civil war about, right? Uh,
Yeah. Yeah.
so we're used to dealing with this debate about what belongs to the federal government, what belongs to the states. Well, one of the things I think that is so interesting about Indian law is that it's a reminder to, like, to my students, to lawyers, hey, you know what? In our country, it's not just the federal government, the states, and the cities. There are these other governments, and they are governments, the tribal governments. How should they all relate? But the point is, we should be able to them into that in the same we've been able to build
Yeah.
a country of out of 50 states.
Well, side note, I recently was able to sit on one of Alexandria's trademark classes, and I was, by the way, she made me sit in the back, and she told me I couldn't ask any questions. So, and it was really hard for me because, as she knows, I always wanted to go to law school. So, nevertheless, I was fascinated by the professor's profound ability to tell a story. So, the hour or so we were in class, just it flew by because of how well he described the various cases, much like what you've done here today, where you've cited cases as, and you have to make a point. So, how do they teach that art of storytelling in law school?
Yeah. So it's a it's a very important part of being a lawyer, and especially of being what we call a litigator, a trial lawyer, but is to learn how to to build narratives and then to communicate narratives, to tell stories.
Yeah.
Um, and a lot of the way we do legal education in the United States, and this wasn't always true, and it's very different from how they do it in Europe. But when we teach law, the way we do it is by giving students these stories. We call them cases, but they're really just stories. And we say, okay, what's the lesson of this story? And is it like that other story, or is it different from that story? Is it like this other one over here? So
Okay.
we spend a lot of time trying to get students to think about why is this narrative different from that one? And what
Hmm.
conclusions can we draw from the similarities or from the differences? It's not something, at least, for a student, like, your daughter's been through 2 years, and um, it's not like there's a class like telling a story, but it's kind of you learn it by osmosis,
Yeah.
it's it animates everything we're doing is just to think about narrative.
Right.
Uh, and I think that's a really good way to teach law and to think about law. In some other jurisdictions, when you go to law school, you just memorize rules, um, and that's how they do it. But that's not how we do it. In our legal system, we've thought about rules and their application as being embedded in kind of, again, human narratives and
Mhm.
characters and things playing out. And to be a good law student and, to try to be a good law teacher is to get comfortable with that.
Very much so. And I can see why it makes an impact, especially as you said, for litigators. I guess you have to be able to do that.
Yeah.
Well, and speaking of storytelling, as you know, Native Chalk Talk is all about the preservation of our ancestral stories and histories. And you're Choctaw, so I must ask, what can you tell us about your ancestors?
Yeah. So my maternal great grandmother, her name was Ola Moran, and
Mm.
she was on the Dawes Rolls in Oklahoma. Uh,
Okay.
I know you know all about the Dawes Rolls,
Yep.
and it's interesting. When I was a kid, I didn't know about this. It was when my great grandmother died, and we were kind of going through stuff, and we found all these interesting papers about um, her grandfather who had gotten an allotment. He had a great name. His name was Marmaduke Moran, which is wild.
That's
Uh,
amazing.
yeah, yeah, but he'd gotten an allotment. I've done some digging. I can't pretend to be an expert, but as far back as I've gone, is that um, I have a relative named Elizabeth, who was a Choctaw who was, kind of forcibly moved from the kind of Mississippi, Oklahoma area
Mhm.
west, first Texas and then up to Oklahoma, and then so the Choctaw connections I have are in Oklahoma, Cole County.
Wow. It's interesting because I have some relatives that also went from Mississippi to Texas first. And in their case, which isn't every case, it was because they were being robbed of their land allotments by this government agent with the last name Ward. Um,
Mm.
but yeah, I've heard a lot of people that went west. They went to Texas first, and then they went up to Oklahoma, and it's kind of interesting. Or stayed in Texas for a while, is what I'm trying to say, and then went up to Oklahoma. But well, I love that Marmaduke name. I think if you have another child, you should name it Marmaduke.
It's tempting. I don't think I'll threaten my wife with that.
Right. Well, thank you, Professor Garnett, for sharing your knowledge and insights with us today. I've learned a lot. I'm just eating it all up, and I hope all of us, native and non-native alike, will walk away with a deeper understanding of how vital true religious freedom is for every faith and every community in this country. But before we wrap up, do you have any final words of wisdom you'd like to leave with our listeners?
Well, I don't know if it counts as wisdom. I just want to say thank you for having me on. It's been a real privilege, a real honor, and I would just leave your listeners with the thought that uh, religious freedom in the American constitutional experiment is it belongs to everyone. It's a work in progress. I think we have made progress, but one of the things that I think we can add to the conversation is to help everybody appreciate that religious freedom has this communitarian dimension as well as a
Mm.
individualistic one.
I love that very much. Well, and as we reflect on the tragedy of the Wounded Knee Massacre, we're reminded that the struggle for Native American religious freedom has deep roots in unimaginable loss and injustice. Yet, despite every attempt to erase their ways of life, Native people have held fast to their traditions, languages, and sacred beliefs. Their resilience is not just history, it's a living testament to the enduring spirit of Native communities, and there's the word community again, who continue to protect what was meant to be silenced. May we honor that strength by listening, learning, and standing alongside them in the ongoing fight for true religious freedom. Yakoki, Professor Garnett, for joining me today. Thanks for listening to Native Chalk Talk. Be sure to join our community on YouTube, Facebook, Instagram, and Twitter, and check us out at nativechalktalk.com. Stay tuned for the next episode. You're going to love it. Yakoki. Thank you, my friends.